What's up, everybody, and welcome back in. We've got a live today breaking down a hearing that was an entire day. It's going to feel like home, right? A live breaking down something happening in court. So much to go through with this hearing, which was actually a lot of fireworks for something that I think should be an easy answer. I hope should be an easy answer. I think we should all know where this is going, although you can never be too sure when it comes down to judicial discretion. But some very fiery arguments from the lawyers that I think is a sign of what's to come in the trial. And I think we learned a lot about what's going to happen in this trial, even if it wasn't going to be the deciding factor in today's hearing. And I'll get to all that. I'll answer your questions. We'll talk about what the lawyers did good, what they did bad, what worked, what didn't work, and what I think is going to happen at the end of the day in this case, and more motions coming from the prosecution with similar theories to what they argued in this hearing. So we are not done arguing about experts yet. Make sure you guys hit the like button. Make sure you're subscribed if you haven't already. Let's get to it. So this was a continuation of the hearing where the state is trying to block the dog bite expert of the defense. Basically, this expert wants to testify that the injuries to John O'Keefe's arm are consistent with or were from a dog's mouth. And, she uses the patterns to show how it was from the teeth of the dog. And the defense is saying she doesn't have the proper experience, education, and doesn't use a methodology that's peer-reviewed or scientifically accepted in the community. Therefore, she shouldn't be allowed to make this opinion in front of the jury because it will not provide proper expert testimony to the jury. Now, if you remember back, she was kind of I don't know if I'll call her a surprise witness. She reached out to the defense and said, hey, I know about dog bites. I see what's happening here. Her and Mr. Jackson, I think, have a mutual friend in California. And she was like, I think I can help because I think it is a dog bite. I've treated a bunch of them. I've treated a bunch of motor vehicle accidents, and it's not a motor vehicle accident injury. So the defense is like, okay, let's do it. They get her in. The judge, if you remember back when, didn't allow a continuance. So the defense, was kind of scrambling. I don't want to say scrambling, but putting together some things at the last minute. And eventually the judge, same judge, Judge Canoni, allowed this witness to testify. She testified. The defense crossed her. They crossed her on some of her biases. Did she want to be involved in this case? Whether or not she did certain testing and things like that. And it comes out a hung jury. So did she matter? We're not really sure in the end, right? We don't know. We haven't heard from a lot of the jurors as to what specifically they hung their hat on and not being able to come to a decision and end up having a hung jury. Well, the new prosecutor, Hank Brennan, is a defense attorney. That is a special prosecutor brought on and paid just for this case. He is a lot more aggressive. And one of the things I hope everybody can notice and see is the way this case is going to be handled and tried is going to be different than the first time. Prosecutors usually have longer directs and shorter crosses. Defense attorneys usually have shorter directs and longer crosses. It's not, something that happens in every single case. I wouldn't say always or never, anything like that. But generally, that's what happens because prosecutors are directing a lot more witnesses in their trial practice, and defense attorneys are crossing a lot more witnesses. The prosecution has the burden. The prosecution calls most of the witnesses. And the defense sometimes doesn't even call a single witness, right? And that's why we hear defense attorneys sometimes lead when they're directing witnesses because they're so used to cross-examination. Well, in case you didn't notice in this hearing, Hank Brennan is going to dig in a lot more, in my opinion, on cross-examination than Adam Lally did in the first trial. While he is a former prosecutor, a lot of defense attorneys are. He's been practicing criminal defense for quite a while now, and you get into a groove, and that's definitely what you get more used to. And he is going to be a lot more aggressive. He's going to be a lot more hostile. And there's a lot of people on Twitter and in my DM saying they hate it. He's a jerk. He's rude. He shouldn't act like this. And I will say, if there was a spectrum from Alan Jackson on one side to Adam Lally on the other, Brennan is much closer to the Alan Jackson part of the spectrum than he is Adam Lally. They both are going to make comments under their breath. They're going to try to control witnesses. They are going to be stern when witnesses aren't answering the questions they want them to ask. There are going to be jurors that like that and people that like that. There are going to be jurors that rub them the wrong way. And I think that's very important to understand. Some jurors may absolutely hate that. They may be like, Brennan's being a big jerk to this poor expert witness. I know Dave Nizer in my firm told me about a case he tried one time where he cross-examined this expert and he's like, I crushed this expert. And then we ended up settling the case in the middle of trial, and he interviewed the jury, and the jury was like, we thought you were a big jerk to the expert. He was like, holy crap. He's like, this person's just trying to do their job and whatever. And Dave is not a very aggressive attorney. He's a good attorney, and he will hold a witness and control a witness and cross-examine them. But his personality is much more passive than Brennan or Alan Jackson or a lot of the attorneys that we have heard. And from my perspective, it's going to depend. It's going to be a juror by juror thing. But I'm confident to say that Brennan has a style, and that's the style that we're going to see in the trial. And that's the style that we heard throughout this entire hearing. So let's get to some of the testimony. And it kind of starts out with, I think this witness, by the way, incredibly respectful, incredibly experienced, incredibly educated. How do you really like she's not a jerk, and she's not trying to do something wrong. She's giving her opinion. And I think Brennan makes plenty of good points for cross-examination, right? You know, the measurements, and we'll get to a lot of it, but just because he might make some good points on cross-examination, which even a defense lawyer whose client is guilty as sin can make some good points on cross-examination. What are we here for? We are here to determine, the judge as the gatekeeper, should this witness be allowed to testify as an expert? That is the really important part of this hearing. And if I can skip to the end here and discuss the arguments that they make, Brennan makes an argument about how this person's just wrong and we know it because of X, Y, and Z. And the defense lawyer makes the argument of, judge, you're the gatekeeper. Here's what the case law says. Here's the standard. She clears this by leaps and bounds. Oh, and let me read what a judge said about her one time, that she does have a unique set of education experience to be able to testify to something like, was this a dog bite? And oh yeah, that judge was you, Judge Cannoni. And we're going to get to the arguments at the end, but that's kind of an overview of what we're getting at in this case. And we're going to show some clips about some points Brennan make, going to rub people the wrong way sometimes. Some of them are good points. And getting into it with this witness, again, some people like that, some people might not. From my perspective, I don't mind an assertive attorney. I don't mind an attorney with a big personality, but I'm not your average juror. So I think it's more important, you know, your average everyday people that might end up on a jury. I also think one last thing, this is kind of a long opening to give you an overview of what happens in this hearing. But we have to remember that these jurors are not going to know what you and I know about this case. So when people say, oh yeah, right, they found Chloe, it's probably a fake dog or something like that, the defense might be able to cross-examine and argue about that if it comes in, right? There's still things the judge is going to have to decide whether or not it's going to come in. But that jury is not going to know what happened in the first trial. That jury is not going to know about everything that we know in this case. And we have to remember that as we listen to, will these arguments work or not?
I know how I evaluate wounds.
You have personal experience where you've treated dog wounds and you look at it and you're simply deciding whether or not to you this looks similar. You're giving your personal aside, aren't you?
I actually find that offensive.
Oh, okay. Well, is that what you're doing?
No.
So if you're comparing it to an actual science, a standard,
He's like, you're just giving a personal aside that this is what you think. She's like, that's offensive. I'm basing this off of treating hundreds of dog injuries, thousands of motor vehicle accidents, the literature that I've read, the studies I've been to, my work as a cop. I mean, she's got experience that like almost nobody has that they can draw from.
methodology. I want to learn that methodology from you. So what I'm asking you is, tell us, where does that come from? The methodology where you have a point of comparison, where you look at a wound and you compare it for similarities to another item.
There are several published peer-reviewed articles that describe what to look for, how to observe, evaluate, and then sometimes treat wounds, dog bite wounds. There are, several authors that have published similar things. And in terms of there being an organization that says, here is the standard for dog bite wounds,
Right.
I don't think that there is one.
When you say you don't think there is one, if you're an expert in this field, you would know that there is not one, is there?
There is not one that I know of, correct?
Well, you're not guessing there might be one you don't know of.
I don't know of any published standard by an organization.
So it'd be fair to say, when you are giving an opinion, what you personally believe to be a dog bite wound, there is no standard in dog bite science that shows you what the standard is. There's nothing to compare it to.
Again, it's based on the a combination of the experiences that I've had over the last 30 years, observing, evaluating, and treating dog bite wounds, plus the numerous articles that I have read on dog bite wounds, their characteristics, morphology, patterns, and other things like complications, et cetera.
Okay, so to get back to my question, I know that you're using your experience and your memory, but there is no standard of comparison. There's no methodology that is accepted as a practice.
I disagree.
Okay. Can you share with us?
And it's fine for a lawyer to disagree with you on that. But she has the articles, she has the pattern recognition stuff that they talk about on redirect, which we'll get to. But they have methodology. The state doesn't like it, and that's fine. If the judge determines for it to be junk science, then maybe she won't keep it in. But the judge already has allowed this once. So it would be very strange for her to overturn her own ruling and her own understanding and decision on this expert. It could happen. I would be surprised.
Us one of those articles that you've been relying on to combine with your personal experience to come to conclusions in dog bite analysis?
Well, there's the Munich that we talked about.
I didn't talk about. Can you tell us a little bit about it?
Oh, certainly.
Okay, please.
Okay, would you like to go through it together?
I'm asking you to tell us about what you're basing your opinion on, and you said it's Munich, so I don't know much about
Okay,
it.
that's one of them.
Well, tell us a little bit about that.
Okay, well, in that article, the authors described a fatal case,
Mhm.
but also described what some of the characteristics are in dog bite wound cases. What types of wounds you see, their appearance, their distribution, their configuration, the different aspects like that. Many of them are parallel. Things that would affect the appearance of wounds that physicians know about, such as elasticity of skin and other ways that wounds can be distorted from one to another wound. So you have to know a little bit about wound characteristics and basically things to look for in the forensic evaluation of dog bite wounds.
Did that article lay out a standard of methodology?
I guess I don't understand what you're getting at.
Rather than having a particular case study where that article talks about a person that was attacked by a dog and deceased, correct?
So this is another case that he kind of conflates the issues on the injuries that caused death versus injuries that came from a dog. Let me know what you thought of Brennan in the chat. Because I see some that said he was on fire. He did awesome, controlled the witness. I see some that said he was a condescending, rude jerk. And if you remember, some of the best attorneys from my perspective, and I won't even say from my perspective, what I'll say is some of the most successful attorneys on paper and by, their accomplishments, their results, the amount of money they charge, whatever you want to call it, have apologized in opening for how they're going to act towards certain witnesses. I may be a jerk in your eyes, but you have to know I am searching for the truth. I am cross-examining. I am making sure that whatever's coming out of people's mouths is true. If not, I'm the one who has to call them on it. I am this person's lifeline, the defendant sitting right over there. So it shouldn't surprise you if, certain lawyers rub people the wrong way, if there's a method to their madness. Now, there's absolutely a line that you shouldn't and really can't cross. I have kind of a sarcastic personality. I really try not to be sarcastic in court, but there are times where I do have to battle witnesses some and try to control them a little bit. And so I will say once in a while, I found myself going, okay, with a little smirk like that when they just refuse to answer questions. Some people may say that as see that as condescending. I think you can read your jury sometimes. And if the jury's feeling the same way you are, that's a home run. If they're not, it's a swing and a miss. Leslie said, I didn't watch much of the first trial, so forgive me if this was asked, but the courtroom seems to be set up different from what I'm used to seeing. Honestly, every courtroom's a little different. Every jurisdiction is a little different. From my perspective, it's not that abnormally set up. Rebecca said, it's because the prosecution's in front of the defense. Sometimes they're side by side. It all depends on how the courtroom's set up. In my 30 years of taking care of dog bites, there is all different appearances. The attorney acts like he's a doctor. I'm going to save, this is a great point. I'm going to save some of my discussion until we get to the closing remarks where the defense attorney's like, there's a difference between doctors and lawyers. Where's your doctor's opinion on this? But there is a doctor opinion on this I found to be very interesting. That was a surprise reveal. There were some surprise reveals during the prosecution's direct. So we're going to get to all of that. Rebecca, thank you for gifting the memberships and congratulations. We'll be talking more about your fantasy football win on another video. Diva Dawn, Peter, is it difficult to bounce from a defense frame of mind to a prosecution to go from trying to prove innocent to prove guilt? We're not always proving innocent as a defense attorney, but I know what you mean. I don't find it to be difficult personally. I would love to prosecute a case. I think prosecuting cases is so much easier than defending cases. You hold all the cards, you have all the leverage, you have all the power. I would love to prosecute a case. I do not think it would be hard to flip there. Now, it may be, I do think it would be hard for a prosecutor who's never been a defense attorney to flip to the defense side and try a case, but they get used to it. And then it's not that hard to do both. From my perspective, I should say. That's just one person's opinion.
In that case,
Yes,
however, in
and
reference,
and
I'm
it's,
sorry, Your Honor, you can finish the question.
Yes. I'm going to let her finish.
please,
And Mr. Leslie, for objections, just simply objection.
I'm sorry, Your Honor, I will finish.
that article, it was a case report, but it was also a review of previous literature. So in the review of the previous literature that had been published, they came up with recommendations. So yes, there are recommendations in that article.
in that article, it talked about a wound to the neck where the deceased bled to death, correct?
Yes,
Okay. It didn't talk about pattern recognition analysis.
I
in that article,
disagree.
did it? Okay. And did it talk about a standard of practice of methodology?
And you see how she says he disagrees and he just moves on. So a lawyer like him who talks a lot, can get loud, can get argumentative. Sometimes if you're not paying attention, you may miss the stuff they gloss over. The judge can't, because they point to certain parts in that article that clear the bar for expert testimony. And Brennan wants to focus on X, Y, and Z, which may be more positive for his case, which is fine. That's what lawyers are supposed to do. But we can't forget that she does have a peer-reviewed article she relies on, even though you don't absolutely have to have that specifically if you have her expertise and education. Future said, I'm much more impressed by attorneys who don't resort to snarkiness or aggressive tactics in order to make their case. I would agree, but I'll say every person has a different style that they like. And when I say like, that they learn from, that they trust, that they find authoritative, because that's important from a lawyer that's trying to prove their theory of the case and the way they see it as the truth. Some lawyers can be found to be boring or not making any arguments or not convincing you if they are monotone or stay a certain way or too soft-spoken. So there's really a balance that you have to strike.
Recommendations.
But that's not what I'm asking you. I'm asking you, did it have a standard, a methodology that it discussed?
These were authors that were practitioners, and they weren't, I don't believe they were in a position to create a standard.
In fact, you can't point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites. You can't point to one article, journal, book.
That's correct.
And so because there is no methodology or standard for you to look at, it involves a great deal of your subjective opinion based on your experience treating dog wounds, doesn't it?
You know, with all due respect, Mr. Brennan, I'm not somebody that just came in off the street. I have at least 30 years as a physician, and I use that information in helping me form my opinions about wounds. I've seen all types of wounds.
Okay, so my question,
She hit him with with all due respect, Mr. Brennan. And she's right. Okay. She's like, listen, you can say whatever you want about how, this book doesn't say exactly what you want it to say, but this is a combination of what I've read, what I've learned. Some of it is peer reviewed, but a lot of my experience is in education. And I can't help but think, like, no witness at a trial says, based on my education experience, more than a cop. It's like, based on my experience, my education, based on the courses I took, which are like a weekend course. It's like, come on. Like, and prosecutors use them all the time, and it's appropriate in cases, legally appropriate. So to act like her education experience should just be thrown out is, So they keep, battling on whether or not it's an appropriate expert opinion. He starts to talk about how she has an interest in this case. He also talked about how, her opinions have changed and why it's a big deal. And again, that's good fodder for cross. If you can impeach an expert witness, that's great. But that's not something that's going to strike the witness on its own. I'm going to jump ahead a little to them discussing her interest, quote unquote, in the case. And he's definitely going to impeach that. From my perspective, once again, this has literally nothing to do with striking her as an expert. If she reached out to the defense and she wanted to be a expert witness on this case and took an interest in it, cared about dog bites, read a Boston Globe article, all that, if she did all that, let's say she did do all that and she was interested and she wanted to be on this case and she called the defense and begged to be an expert and they said yes, you can cross-examine her. You can say, hey, look, maybe this lady has an interest. Are you going to believe everything she says to the jury? But that doesn't mean she did anything unethical. It's not like in the Richard Allen case where she was going on, at least we haven't seen that come out, Facebook stuff and looking into stuff and making comments and reading everything everybody's saying about the case. She just said, hey, I think I can help you with this case. And if that's true, maybe the jury will find her less credible, but it does not strike her as a witness. And so much time, from my perspective, was wasted. The defense didn't really object. I would have kept objecting like, Judge, this is all outside the scope of this hearing. If he wants to take a deposition, actually, I don't know the rules in Massachusetts. Maybe he can't take her deposition. But this shouldn't be a deposition, in my opinion. In my experience, I should say. But let's hear him discuss a little bit about her interest in the case.
Process of differential diagnosis anyways, other than car accident.
Could these have been self-inflicted, for instance?
You went through that process?
I did.
I didn't see that anywhere in your report
It's in
whatsoever.
my head. I didn't write it down.
Well, aren't you supposed to report the process you go through before coming to conclusions? Isn't that why you wrote a report in discovery and disclosure?
Yes, but
Okay. Is there anything else in your head that you thought about that you didn't put in the report or tell anybody? So we have car accident, we have suicide, we have dog bite. What else did you think of in your differential diagnosis?
well, I thought, could it possibly be road rash?
Okay. What else did you think?
Oh, I don't remember all the things I thought of at the time, but it wasn't a very large list.
Hold on, I don't have the right timestamp, but now that it's actually all come up, I can go to the right timestamp. 57.
Would it be worth writing down? No, I don't think so.
But was there any other significant causes that you went through and vetted through differential diagnosis that you didn't write down?
Not that I remember at this time.
And that's why it helps to write it down. Okay. So one of those causes of these abrasions that you went through differential diagnosis for was car accident, wasn't it?
Yes,
In fact, when you first met the defense attorneys, you had an interest in this case, didn't you?
I thought I could clarify the issue of what those wounds were caused by.
So you were learning about information about the case publicly before you got involved in this case,
No.
didn't you? Well, you knew there was an issue.
I heard, yes, I did know that there was an issue. I saw something in the Boston Globe, and Mr. Brennan, I wasn't following the case at all. I don't even subscribe to the Globe for information about this
You don't-
general region.
You don't have to be defensive about it. I'm just asking you.
Okay,
You knew
just
enough
clarifying.
that you wanted to get involved and you made some phone calls.
Those comments, right? You don't have to be defensive about it. Technically inappropriate, but lots of lawyers do it. And usually the more comfortable, the more confident, this type of a personality. I think Alan Jackson would say the same thing. We haven't heard him say it right here, right now. And I keep using him as an example because he's in this case, but I think lots of defense attorneys that some people like, some people think are too aggressive would make comments like that. The judge had to tell lawyers on both sides to not make comments like that. Yannetti as well, Lally as well. And it's like, some people like it, some people don't. From my perspective, I don't think he was like a total a-hole to her. I do think if I was him, if there was a jury there are certain things I would not have said and done, but there are others that maybe some people would have found rude that I would have tried to box a witness in on.
Calls to offer your services.
I didn't want to get involved, but I thought that I should.
I see. And so you learned enough through your study or the Boston Globe or television that you knew generally that there was an issue about the abrasions, correct?
I knew there was a question, yes.
You knew that the defense was claiming that a dog caused those injuries.
I wasn't even sure who was claiming what at that point.
So you didn't know much about anything, but you still made phone calls to introduce yourself to get involved in the case?
Again, I know that there are very few people in this country that have the combination of experiences that I do, and I thought that I could just clarify the issue and maybe help people move along in the case.
Before you decided that you were going to offer your services, what did you know about the case?
By the way, all of these points, you called and inserted yourself in this case. You offered your services in this case. That is not grounds for striking her as an expert.
I knew that a police officer had died. I was a former police officer, so I knew a police officer had died. And I knew that there was a trial. And I didn't know details really. I just knew that I believe I read that there was something about a car accident versus dog bites. That's about all I knew about the case.
Had you seen any photographs?
No.
So just generally knowing that there was an issue, you thought you could help because of the word dog bite in your experience?
Correct.
Okay. So when you ruled out motor vehicle accident, is it fair to say that your perspective was a motor vehicle accident would have caused injuries to the other parts of the body, and that's why you consider car accident as...
So they go through for a second why she believes it's not a car accident based on his questions like that. And then he's like, well, you're not an accident reconstructionist, right? It's like, no. On redirect, when the defense attorney gets up, Alessi, I think his name is, I can't remember everybody's name anymore. But he gets up and he's like, do accident reconstructionists treat patients that come in for motor vehicle accidents? No. Okay. Do accident reconstructionists treat people that come in with dog bites? No. Okay. Do DNA experts treat? It's like, no. You know who treats them? Doctors like her. And that's who we need. We need doctors like her treating people in these situations. And from my perspective, that's a good thing. That's a good thing. And I think there's plenty of cross that maybe the jury won't find her incredibly credible, or maybe they'll find certain things are credible, certain things aren't, and that's their job to do. But to strike her completely as the gatekeeper, as the judge, would be abominable. Bob Jr. said, "Hi, Peter. This case is when I became a member and now refer to you as my lawyer buddy." Bob, we're boys. We're boys, Bob. Blows my mind that they will be able to get a jury. Feel like everyone has an opinion. I don't envy them. That's going to be a tough voir dire, a really, really tough voir dire in that area and around the world, frankly. Then he starts to ask her, do you know if there's any DNA, or did you know that there was DNA on the car? Did you know that there was hair on the car? Did you know that there was tons of shards of glass right across the arm where these injuries occurred? Did you know that he was hit out of his shoes? All of these comments he's saying as if they're fact. We do get some objections. Eventually he has to say allegedly. Let me see what else we have. Oh, he does get her to say a dog wouldn't do something like that, hit somebody out of their shoes. And she says, no, I don't think that they would. That's pretty good for cross. Again, for cross, not for what we're trying to do here. Then I thought this was interesting. He starts to ask about some of the comments that Karen Reed made in interviews, which, once again, I'm repeating myself, but this is all I was thinking the whole hearing is like, what does this have to do with striking her as an expert versus, sure, you can cross-examine her and say, your theory of what you think happened, doctor, doesn't even fit what Karen Reed said in this interview. Fine, you can do that on cross, and I think it may be effective. But it does nothing in this hearing from my perspective.
Reported that the defendant and Mr. O'Keefe got in an argument shortly before this happened?
Yes, I know that.
When you were considering the cause of these injuries, did you consider Ms. Reed's statements herself to not just witnesses, but to the public, to national magazines and programs? Did you consider any of that?
I don't read the national magazines.
Well, would it help you if you knew she told
Imagine taking that and basing your medical opinion on it, but that would be interesting, right? I mean, that would be interesting.
Boston Magazine that maybe John hit the back of her car, telling her to stop, and then she ran over his foot, or she clipped him in the knee, and in his drunkenness, he passed out. Would that help in your differential diagnosis?
Objection, Your Honor.
I'm going to allow it.
To say maybe you did, whatever. You guys get it.
It wouldn't help because those wounds were caused by a dog.
Well, if you believe that statement that she said about running over his foot and clipping him, it would help you conclude that it wasn't a straight-on accident, that it was on the side, right?
Objection, Your Honor.
I'm going to allow it.
It's like to say it could be X, Y, or Z, and you're like, yeah, I know that it's Z. Well, somebody said it could be X or Y. Okay, but I know that it's Z. That's basically what's happening right now. Which, again, cross-examination, fine. Maybe the jury thinks it's X or Y. What else is a problem with this is don't get these burdens twisted. Okay, as we're listening to this hearing, the burden rests fully and firmly on the state. The state must prove this case beyond a reasonable doubt, and they must exclude all reasonable doubts. So they have to prove it was not a dog bite. They have to prove that it was a car accident. The defense does not have to prove beyond a reasonable doubt that this was a dog bite. Let's not forget that.
Even if it were on the side, the car did not cause those injuries.
And we talked about when someone's hit on the side, they could brace or defend themselves, correct?
Oh, correct.
Right. And do you know that if John O'Keefe was standing up and his arm was bent, it would be about the same height as that taillight?
Yes, that I understand. I've been hit on the side. I know about side injuries, side swipe injuries.
Yeah, clip. It's different, right? And so knowing that his height matches up with the taillight, what other evidence would you want to know before you excluded the taillight as a cause of injury? To be thorough, what else would you want to know?
Well, I see pictures of the fragments of the taillight, which I eventually did. And were there any pieces of metal that had the configuration, anything that could cause those parallel lines with the punctate injuries in between?
And again, he's like, well, you're not an accident reconstructionist, et cetera, et cetera. Oh, now he goes through some of the, evidence she doesn't know about, which again, I don't think matters for this, but I do think this could be an effective way to present it to her in front of a jury, depending on how the evidence comes out, right? And it's funny, when we just see lawyers argue, it sounds so good, right? It sounds so clean. I mean, you guys don't like the way he's doing it, but it's like, did you know about the DNA and the hair? And did you know about the shards of plastic that were embedded in his arm? And did you know the lack of dog DNA? And he's going to summarize all of it. And it's like, yeah, but did you know about the red Solo cup? Did you know about, this? Did you know about that? Did you know about where this stuff was found and how it was found over numerous days and all the issues with the investigation, the collection of evidence? All that's left out when a lawyer gets to summarize it in a question, but still can be effective on cross because it can sound good coming from a lawyer's mouth.
I want you to,
I'm sorry.
So let's hear the question.
when you were ruling out the taillight as the mechanism of injury, when you excluded it in your differential diagnosis, and you said to a reasonable degree of medical certainty that these injuries that you looked at were caused by a dog bite. Now that you know that there's a debris field of shattered taillight right near the body of Mr. O'Keefe, and now that you know in his very sweater where the abrasions, the same arm under them, is littered with shards of taillight from that Lexus, does that in any way change your analysis in your differential diagnosis, excluding the car as the mechanic of injury for that abrasion?
Objection, Your Honor.
I'm going to allow that minus the police officer, the detective.
No, it doesn't change my my conclusion that those injuries, those abrasions were caused by a dog bite.
How do you think the shards of taillight got into his sweater?
They could have got into the sweater from an accident, correct?
From an impact with the taillight, yes?
Could be.
Right. And when the taillight breaks and there's jagged, irregular, linear, sharp edges from that break, what do you think is going to happen to the skin when those shards impact the skin?
They could cause injury, yes.
They could cause puncture wounds, couldn't they?
Yes, they could,
They could cause scratches, couldn't they?
but not in that configuration.
I need to ask you the question so you can answer my question. They could cause scratches, couldn't they?
They could cause scratches.
And you have no studies on how abrasion looks after an impact with a taillight that is shattered. You don't have any studies or comparative analysis there, do you?
I have no studies. I just have my years of experience.
He sounds like a defense attorney there to me. He's doing a good job poking some holes, right? Poking some holes in her theory that this was a dog bite. Problem is she is resolute, and it makes complete sense anytime they start talking about the taillight in the car accident that this does not seem to match up with a car accident. He can argue why it might not be dog, right? And he's going to measure, and we're going to talk about, going and taking a mold of, Chloe, is it Chloe? We don't know, about her mouth and whatever. And he's going to poke holes like a defense attorney does. The major $1 million question, though, is where they struggle. Andrew Hansen said a dog might pull off a shoe of someone 100%. I've actually seen it. I've had a dog bite case where a kid lost both shoes because the dog was literally throwing him around. So it can happen, but she said, yeah, I wouldn't think so. And that's her testimony as the expert, right? MT said, as a physician in plastics, after reading the autopsy and assessing the wounds, I thought the exact same thing as this expert. Why is her ER/MD credentials not enough to be an expert on this? So just because you're a doctor doesn't mean you can be an expert on all kinds of injuries, right? Usually you have to have some kind of specialized knowledge. She specifically treated dog bite wounds. Like if this was a bee sting and she'd never seen a bee sting case before, she probably can't testify about bee stings, right? Even though she is a doctor and it's medical treatment, it has to be something that she actually has expertise in. She went above and beyond, took certain courses, read articles, was a cop, and reported to some dog bites and car accidents. So she has a lot that goes above and beyond. And again, there's not always just one bright line rule. Wouldn't that be so easy? But the law makes it more difficult, where it's like, if you're a doctor, you can testify to X, Y, and Z. That's just not how it's written. Although it does matter. It's a very, very big and important part of this analysis. Peter, would she be allowed to present similar pictures of dog bites to compare, and why didn't they do this? Why didn't they do this? I don't know what you mean by why didn't they do this. She could present pictures of what a dog bite injury looks like. I should say, in certain cases, in certain jurisdictions, she would be able to compare what dog bite injuries look like. Now, that can't be dispositive. It can be part of a presentation. It can be part of a report. It can't be that, these are the exact same, therefore it must be from a dog. And frankly, the prosecution then could say, well, here's a dog bite injury that looks nothing like this. So sometimes it's not that effective, but there are certain situations where you can produce certain things like that. Brianna said, why is a dog bite so important? Well, that's a good point too, because technically, well, here, I'll answer your question, but technically he could have got bit by a dog and hit by a car, right? Two things, those both things can be true. The problem is two completely separate theories. Is the state says those injuries on his arm came from the taillight, and the defense is like, no way they didn't. And therefore, if you can disprove that that's where the impact of the car was, maybe you can disprove it was a car at all, then the state loses their case. Elise said, I think Chloe jumped him when she went potty, knocking him over, biting his arm. She went back inside. No one knew he was there till much later, like 2:30 when the search was made online. That would be not guilty, right? Which is the ultimate question. I don't know what happened, but I know that's not the state's theory and what they're trying to prove beyond a reasonable doubt. Let me see. Was there anything else? Oh, we'll listen to one more minute of this because an interesting point comes out.
You know what wasn't found to trace evidence in that sweater? DNA of a dog.
I understand that.
You know when dogs bite, saliva, foam, sweat in their mouth, correct?
I also understand that there were issues with the collection.
Well, we're going to get to your claims and see if there's any basis for it, but that's not the question I asked you, but I will invite you to talk about that in a second. Looking forward to that.
So I know your claims about collection, and I invite you to talk about it, and I look forward to it. I don't really think they dug in that much. He does hit it, and we are going to talk about it, but so whenever any of these defense witnesses want to talk about the collection of evidence, he seems very excited to talk about it, like he's really going to hammer that down. Okay. I'm interested to hear how he explains the red Solo cups and the Stop and Shop bags and the multiple days of going back and forth and finding more and more some big pieces that potentially should have or could have been found. He's going to have to at least admit bad police work, right? Which it very well could have been. But I can't wait to hear how he thinks that they did a good job. I would think he'd be salivating as a defense attorney with the way the evidence was gathered and the investigation went in this case. She talks about how the presence of evidence is more remarkable than the absence of evidence, which I think is a really intelligent point. That the lack of evidence, we can explain a lot of things. It was snowy, it was windy, maybe it blew away, maybe somebody didn't see it, maybe it was planted, maybe not, maybe something screwed up, maybe somebody dropped the ball. There's a million reasons why something might not be there, but what is there is important. And that's when she talks about the wounds and how they are, the shape especially, or et cetera, things like that. They do fight about, I guess I don't have a clip about the collection of evidence. And he's like, what evidence do you have that there were errors? Which is not a fair question because she didn't collect all the evidence and do all the work on the case, right? So if she said there was red Solo cups, it would only be from watching the prior trial or talking to a defense attorney, which he can make sound nefarious. So it's kind of like lawyer speak and lawyering her to make it seem nefarious if she knows about the not great evidence collection, but it is a thing. It is a thing. I did think it was a good point when Brennan talks about how she said prior it could be teeth or it could be claws. The fact that her evidence or her testimony changed, it is what it is. But if you think that if you say to a reasonable degree of medical certainty, this was a dog bite, this was teeth, you really shouldn't think that it could have also been claws. My perspective. I would feel more confident and she would be more credible and believable if she said, no, it's teeth. Be resolute, be confident, but it could also have been scratches. Well, then I guess it could have also been a car. And from her perspective, I mean, she said it was not a car. So I'm just saying, like, when you bring up possibilities, there's lots of possibilities, but she's not a state witness. She's a defense witness. So the burden is different in that there is no burden. The defense attorney stands up, shouts objection. The judge is like, chill. This is going to be a battle at trial, no doubt. Both of these attorneys were fighting hard, battling. They were not afraid of the court. Alessi, I think is the defense attorney's name. He's like uber respectful, but he's not respectful in a passive way to where he doesn't do what he thinks is the right thing to do. He will always do what he thinks is the right thing to do, but he will do it being cordial and respectful and apologetic to the court. I like that kind of a style. He talks about how, well, what if he was defending himself from a car? It's like, what? What? I'm interested to see if the state has a completely different theory about the mechanism of injury and how his body moved. If the defense calls Trooper Proctor and was like, you were the state's expert the first trial. You said he did X, Y, and Z, right? All right. So I've got a couple comments on this. Wafa said, Peter, an FBI expert said it was not a dog bite. So why is it that people give importance to one FBI report but not the other? The same way people like Jackson being aggressive but not Hank makes no sense to me. Love the coverage. Ginger said, what are your thoughts on him saying that the Fed's deputy medical examiner said no dog bite, yet he is trying to toss the ARCA guys? Seems like me he's trying to use a sword and a shield with the FBI guys. So kind of similar questions, maybe people seeing it two different ways. Well, we're going to get to that. And we're going to listen to him discuss something I found pretty surprising and I didn't know existed. And that's the fact that there was an FBI medical examiner that I don't remember coming out in the first trial. You guys can correct me if it did, that said this was not a dog bite. And we'll talk about some of the context that the defense, people complain sometimes that I scream into the mic. I don't mean to. Sometimes I get excited. But we are going to talk about how the defense gives some context to this. So let's kind of listen to what those last two comments were discussing. It was a revelation that I was like, oh, wow. Oh, wow.
Okay.
And this, by the way, was not somebody connected to Proctor or to this DA's office or to Morrissey. This was an FBI examiner.
Who peer reviewed?
I mean,
findings?
this case?
Yes.
Oh, no, not this case. No, I thought that this information was rather confidential, and I didn't share this information.
Well, you discussed with the defense other information in this case, didn't you, about the accident and about people's opinions? You've discussed that as part of your opinion, haven't you?
Yes.
Okay. Did you know that the U.S. Attorney's Office employed a deputy medical examiner to look at these bites? And then he had commented that the wounds at 2 to 3 millimeters up to 7 centimeters were documented on Mr. O'Keefe's right arm, and the injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. Did you get that expert opinion from the United States Attorney's Office when they investigated?
That's pretty good. That's pretty good for the Commonwealth. I get it. People are going to be mad and they don't want to hear anything that might be good for the Commonwealth. Okay, that's fine. I feel like that's pretty good. And I think that that's a pretty good argument from the Commonwealth. Guess what? If we're going to say the FBI is the authority here, which they're not going to be able to say, ARCA experts, FBI, deputy medical examiner, FBI, they're going to say, independent third party or whatever language they used. And from my perspective, you walk a dangerous tightrope as the prosecution saying we don't want to rely on the FBI because fine, FBI says unlikely to be a dog bite. FBI also says unlikely to be a car accident. And if it wasn't a car accident or hit by a car, you lose as the Commonwealth.
Investigated this case to consider as part of peer review?
Objection, Your Honor.
No, I did not get that, but
Did you say you did get that?
no, I did not get that. However, I have a comment about that.
Please.
Not very medical exam. Not very many medical examiners have the experience that first of all, have experience with dog bites, seeing hundreds and thousands of dog bites and treating them. And not very many medical examiners have even autopsied a case of dog bites. So although, some physicians have certain opinions based on what they know, they don't have my experience. I'm
Do you
sorry.
know if Mr. Walsh has your experience?
And so what does she say? No, she didn't say this part, but I was kind of thinking it's like, oh, so Mr. Brennan, you're okay with this deputy ME that none of us have ever met before. And we don't know his resume saying that it wasn't a dog bite as if he's some expert. But you're not okay with her. And maybe it didn't come in. Maybe the defense said that person's not qualified to make that opinion. That could be true too. If I was the defense, I would absolutely file that motion now and say, look at all the experience that Dr. Russell has. That deputy ME has none of it. There's no way the prosecution will be okay with us calling him. So why should they be able to? So maybe it gets tossed. Maybe it doesn't come in at trial.
Or not?
I don't know who
The
was it?
gentleman who gave this opinion that was employed by the federal government. Do you know if he had your experience or
What's
not?
his name?
Mr. Walsh, John
No,
Walsh.
No, I don't.
So he could have more experience for all you know.
Oh, I'm highly unlikely.
Okay, you have more experience than anybody in the country.
I think I have at least as much experience as any other possible person in the country. And I have it from
And lawyers love to, like, he gave her kind of a sarcastic smirk, like, so you're the end all be all. You're the most experienced expert in the country. And I have to say, That's fine. And some jurors will hate that. Here's the problem. You gotta catch vibes, right? As a lawyer, a lot of this is about catching vibes. Dr. Russell, now, if I sat there, if Mr. Jackson sat there, maybe if Mr. Brennan sat there in that witness stand and said, I am the ultimate expert on this issue. Some people may say, you guys are the worst. You're so cocky. You're so condescending. You think you know everything, right? Certain people with certain personalities, people can say that about. And it might come off as very, ugh. But I don't feel like Dr. Russell has that disposition. I really don't. I don't feel like she has that disposition. And so to sarcastically be like, oh, okay, so you think you're the end all be all, it's like, she has kind of a weird resume that makes her oddly good at this. Cop, doctor, medical examiner, ER doctor, forensic pathologist, interested in dog bites, reading these articles, going to these conferences. It's like, what other person has done that? It's almost kind of strange, right? Like, I don't know if any other person has her resume. Maybe they do, but she does have kind of a strangely specific resume for this, personally. So you got to be careful which witnesses you try that tactic on.
From both aspects, from the clinical aspect and from the forensic aspect.
Did you review the opinion of Dr. Kenneth Kinsey, who said that those injuries were not caused by a canine?
Question. Dr. Kenneth Kinsey. Is that the guy from Murdaugh? I didn't have time to look this up between finishing listening to this and starting this video. But if that is the guy from the Murdaugh case, he was not a medical doctor, was he? I thought he like reconstructed how the shots went and where the body positions were and things like that. I could be wrong, right? Watched a lot of trials, have a lot of cases myself. My brain could be turning to mush with that, but he was not a medical doctor, I don't think. But is he one of the state's experts in this case? Because, oh boy, would that be interesting. This feels like the Twilight Zone. Again, it feels like we're living in a simulation. Like they're going and grabbing, categorically, this guy was liked by most in the Murdaugh trial. What's going to happen if he testifies for the Commonwealth in this case? I'm very, color me intrigued.
Dr. Who?
Kenneth Kinsey.
No.
No. If you look, I believe Mr. O'Keefe's arm were completely bent when he sustained the injuries. A lot of them match up. They're a continuation of another injury.
And I don't even know who Dr. Kinsey is.
Okay.
Is that a medical doctor?
So you don't have any peer review at all. You have nobody who's given an opinion similar to yours.
You notice how he didn't answer when she said, is he a medical doctor? By the way, he doesn't have to. He's a lawyer. He's not on the witness stand. He doesn't have to answer her. But if I'm the judge, that has to matter. Like, who are we comparing this to?
About this being dog bites, do you?
Is Dr. Kinsey, I'm sorry.
You have no peer review. You have no peer endorsement. Everything that you have no peer endorsement for any of your opinions, do you?
I didn't think I was allowed to show these pictures to anyone.
When you're giving opinions about the teeth and suggesting that might be bad, things you don't really know about, you would agree it would be best to
Things you don't really know about, right? Like, not a question. That's not a question, sir. And the defense could object to that. And that's exactly what Judge Cannoni was getting on the lawyers for doing in the first trial.
look at the dog, Chloe itself, right?
Not necessary.
If you looked at Chloe and examined Chloe, you would know whether or not there are any irregularities in Chloe's teeth, wouldn't you?
Yes, I might.
You would see it, wouldn't you?
Well, if I got close enough, and
Right.
I don't know if I want to get close enough to Chloe.
Well, why wouldn't you want to? You're a medical doctor. You want to have an opinion to a degree of medical certainty. Why wouldn't you want to?
She smartly throws in there like, I kind of be afraid to be around Chloe, right? She bites these people. I don't want to be around that dog.
To see the best evidence of the distance between the teeth and Chloe? Why wouldn't you?
I'd have to make sure that I wasn't putting myself in danger.
Okay. And if you saw Chloe, you could see if there was any missing teeth, couldn't you?
Yes.
You could actually measure the canines in Chloe, and then you could compare them to what you're calling dog wounds on Mr. O'Keefe's arm. You could do that, couldn't you?
I would have to get a veterinarian
Mhm.
to sedate the patient, the dog, because that going near that dog would be very dangerous. They'd have to sedate the dog to measure the intercanine distance.
What if you did get a veterinarian to sedate the dog,
Uh-huh.
and then you could safely go and look at Chloe, and you could actually take a mold of Chloe's mouth, right?
Mhm.
Yes? You've read that in the
One-
literature.
yeah,
The
one-
best
yeah,
way to
one could.
I'm sorry.
There's only one person who does it.
You've read in the literature the best way to compare the teeth and the mark is you actually do a mold of the dog's mouth. You know how valuable that can be in analysis, don't you?
It can be, but the question, I believe the question here is not which dog created these wounds, but did a dog create these wounds?
That's not my question. My question is, if you took a mold of Chloe,
That might not be your question, Mr. Brennan. But once again, for a defense to provide an alternate theory is not the same thing for a defense to have to prove beyond a reasonable doubt which dog did this. She doesn't have to say it was Chloe. If it was a dog bite, it was not a car tail light. And so that's why, again, certain jurors, they may be like, I'm just telling you, okay? I've had even jurors say this to me. They're like, we were just listening. We believed what you were saying. We agreed with your theory from opening statement. And when you would ask a question to a witness, we were like, yeah, what is that? That doesn't make sense to us. Or if you would say something like, that's not in there, we believe that it wasn't in there. They didn't even go check the records or the evidence. So certain jurors may just believe Hank Brennan and be like, yeah, this doesn't make sense. She's not connecting these things up. And from my perspective, that could happen. But it really, really is not what we're doing here. What we're doing here is presenting an alternate theory. And she says the evidence points to that this was a dog bite, not a Chloe dog bite. She maybe thinks it's Chloe. I've always thought that was kind of a bad move to really box yourself in. But the defense does not have to prove which dog did this. They are poking holes in the theory that this was a car.
his mouth, you would see the distance between the canines.
I'm going to jump ahead a little bit to where they drop this other truth bomb that I shouldn't call it a truth bomb because I don't know if it's true. I assume it's true because I don't think lawyers generally lie in court. But this is something I absolutely did not know happened. And that was that the prosecution went and took molds of Chloe's mouth, and they are going to do measurements and show how her teeth do not match the punctate wounds or whatever they call them on John O'Keefe's arm. I think that's great. I think that's a great argument. Now, is it Chloe? We don't know. We'll have those arguments. We'll have those discussions. I'm sure the defense will fight it if they can. But that's great argument for the state to poke holes in the defense's expert testimony. But you know what that doesn't do? Number one, it doesn't prove that it was a car that hit John O'Keefe. And number two, it does not prove that Dr. Russell should be excluded as an expert. There's no jury here. This isn't the trial. A good cross-examination by Hank Brennan is not going to win the day. Yes, I know that it's years later. Maybe her mouth changed. Maybe she lost teeth. A lot of things could happen. But we'll wait and see what arguments the defense makes based on what they find.
Chloe's mouth, did you?
It wasn't necessary.
Well, did you go up and take pictures and measure the teeth of Chloe?
No,
Did you ask to?
no. It was my understanding that Chloe was in another state. But again, I didn't think it was necessary. And I have reasons why I didn't think it was necessary.
You thought that Chloe was in another state. Did you ever discuss going to see Chloe and doing these studies on Chloe so you could see if they were dissimilar to these abrasions?
I was asked to evaluate the wounds.
Do you know that Chloe exists, that we provided notice to you, that we went up and saw Chloe and took molds? Did you know that?
Objection, Your Honor.
Did you know that? Point allowed. Did you know that, Doctor?
I do know that now. Yes.
Did you know that before you testified the last date in this case, that we actually went up and found Chloe and took molds and measured the paws and the teeth? Did you know that we did that?
I don't know. I don't recall.
Before you came in and testified at the last hearing, you don't recall whether you knew that Chloe was available?
I believe I knew that there was a consultant, that you hired a consultant, and I didn't know what that consultant was going to be doing.
Okay. Now that you know that Chloe's available, wouldn't those molds be helpful? Wouldn't you want to look at them and compare them to the distances on the abrasions on Mr. O'Keefe's arm?
Objection, Your Honor.
I don't think it's necessary for many reasons.
If the distance of Chloe's canines is significantly different than these abrasions in this picture, you would agree that the abrasions in Mr. O'Keefe's arm could not have been caused by Chloe. Would you agree?
No, I wouldn't agree to that statement. Again,
She stands firm, and based on my very limited knowledge, not an expert on the. I do have my doctorate. I don't call myself a doctor, but I do have my doctorate. Not an expert on dog bites. Somebody else said Kinsey is a doctor of philosophy. Yeah, probably not as good of a education and experience as she is to do this. But I agree with her statement, and it makes sense. And she explains it more about how teeth move, the arms move. It's not a perfect measurement every single time, especially, years later with dogs. Maui Mama said, Hank is presenting his case to the public. Well, I hope not. Because if this is your case, you've proved nothing. He's poking holes in the defense's theory, but none of this is proving that this happened in a car accident from my perspective, because this is just a lawyer's question, not things that are going to come out in evidence. Better Rose Fangirl said, Peter, why is Hank spending so much time and energy trying to exclude witnesses and not proving their own case? Well, if he can exclude all these defense expert witnesses, it does make it a lot easier to prove their case without the jury having other theories to consider. So it is a way to help prove your case in trial. But this is all pre-trial, right? He's not spending trial time focusing on the defense case, at least yet. He may, we don't know. But he's doing exactly what a lot of lawyers do. If you don't think these experts are qualified to testify and they're going to give the jury junk to confuse them and maybe result in a verdict that is against the interest of justice, you should try to exclude them. Is he right? I don't think he's right about Dr. Russell. We'll see what happens with the other ones.
Because of various factors such as elasticity of the skin, shrinkage, there's various factors.
So if I understand, you have no interest in examining C and Chloe. It's irrelevant to your opinion?
I don't think I need to see Chloe.
Well, you said earlier when I asked you about particular wounds, it would be helpful to know these things about missing teeth and spacing and distance between the canines. Is that no longer helpful to your opinion?
No, I think you're mischaracterizing what I said. I believe I said that it would give information about the condition of the teeth now, but it wouldn't give information about the condition of the teeth when that incident happened.
In the spirit of medicine and science, isn't more information good?
Generally,
But you generally would not want to go see and examine Chloe.
I don't think it's necessary, and there's so many reasons why.
Okay. Thank you for your time.
Yes.
And if she sticks to that, it is what it is. She doesn't need to measure them, especially because it's changed. That would be like saying, come measure my waist now, when 10 years ago, what was my waist size, right? I mean, it's like, so what? So you know the measurements now. What was it back then? Things can change. Greg said, I think it'll end up in a hung jury again because half the town thinks innocent, the other half thinks guilty. If it does, do you think the Commonwealth will retry it again? Brother, that's a question I do not know. I do not know. They seem to have dug their heels in. They don't seem to be going away based on a hung jury. Grace Bay said, when he says there's no studies on wounds from a broken taillight, isn't that kind of an own goal? How does he know it's a taillight then? Again, that's exactly why that's not the standard. You don't have to have some article that says this is exactly how you know every single time a taillight causes an injury or exactly how you know every time a dog bite causes an injury. There's so much that goes on to it. That's why you need experts with education and experience that also have studied this specific area, have treated these specific injuries, can contrast and compare them with car accident injuries. That's what you need. Who have seen it with their own eyes as a cop. That's what you need. All right, so then we get into the redirect. And these questions were much less newsworthy, much less shocking. And instead, they basically just focused on the standards, what she reviewed, her education, her experience, what the articles say that she relied on, whether her former testimony was consistent or inconsistent. But at the end of the day, this is what this hearing should have been about. It should have been shorter. It should have been more boring, frankly. It should have been focused on our education, experience, methodology used, whether or not it's something that can assist the trier of fact and that a normal person just with everyday knowledge would be able to know or not know, generally speaking. Pathognomonic or whatever he talked about, like when you get the right answer that it's a dog bite, you don't really need to rule out a lot of other things, right? You can, like self-inflicted or a fight or a car or whatever it may have been. We'll listen to some of the responses they gave to some of the points Brennan made. But again, a lot of this was based more on the standards for experts, but there was a little bit of talk of the facts.
Dentition was used to produce them.
So what that means is that if the bite does not include the full, well, let me back up. What it means is the appearance of the bite will vary depending on whether or not all of the teeth impacted the skin or just some of the teeth impacted the skin.
Please read the next sentence.
Only in ideal circumstances will a complete impression of all frontal teeth be found, and often only a prominent canine impression can be seen.
Is what you just read relevant at all to what you analyzed with regard to the wounds of the decedent in this case?
Very relevant.
How?
Because many of those wounds on Mr. O'Keefe's arm were only partial bites. They did not have the complete dentition.
Do you recall Mr. Brennan saying various times that you have no support for your pattern recognition methodology?
Yes,
Is this support for your pattern recognition methodology?
yes.
Is it direct?
And I mean, that's clearing the bar further than you even need to based on the other things they've already talked about in her education experience. And I was wrong. They weren't responding to facts here. This was specifically to the standards and the methodology. And this is what this hearing is about, among other things. But from my perspective, the defense focused on the right things in their questions and in their argument later. The prosecution focused on some good arguments and some good cross-examination, some things we didn't know. And they're definitely fighting this case harder and very different than the first time around. But to me, the answer to Ashley's question should be simple. Dr. Russell should absolutely be able to testify at the second trial. Now, my real only question is, will her testimony be allowed to be expanded? And we'll talk about that in a minute. Glenn V said, how can they prove the dog is the right dog? Glenn V, I'm not picking on you at all, but if the prosecution gets the jury to start asking themselves this exact question, well, then their theory and their arguments and the way that they're putting these arguments together is working. It's like, they don't even know it was Chloe. Can we really trust them? Is it really that credible? Start asking those questions, then maybe you might start leaning toward the prosecution side. I'm not saying you are. I'm just saying that's what the prosecution's trying to make people think. But in reality, if I'm the defense, I got to make it clear, which is why I don't love the conspiracy theory or the cover up or whatever you want to call it. They don't have to prove which dog caused this bite. They don't have a burden. They're proving it was a dog, not a car. And if it wasn't a car, the state loses. JC makes a great point. Experts aren't always correct. It's her opinion. It's whether or not she should be allowed to give this opinion. Doesn't mean she has to be 100% correct. Doesn't mean everybody has to think she's correct. Doesn't even mean the judge has to think what she's saying is correct. Is she getting there the way that she should legally?
Direct support for the pattern recognition methodology you have applied in this case?
Yes.
Is there another article? You mentioned two. You mentioned the Munich and Pollock. So let's turn to, and Your Honor, this will be the second.
And it's funny, they talk about how like one of these articles was in the book that Brennan cited as the authority that I don't think this doctor had read, but that Brennan was trying to use as like, you don't even know what's in this book kind of thing. They also answer the question, do you need to see Chloe's mouth to determine if this is a dog bite?
Oh, you heard it, and I'm going to move on.
Thank you.
You're welcome. I'm going to move on to a different section. You have been asked on cross about whether in your emergency department experiences, well, let me rephrase that. In your emergency department experiences with dog-inflicted wounds, have you ever gone to see the dog in question?
No.
Do emergency medicine physicians need to go see the particular dog or any dog in question to determine whether a wound is from a dog as opposed to some other cause?
No.
Of course not. Now, investigators, cops, maybe they would. Maybe the cops should have in this case to rule out that it was Chloe and say, no, this mouth is much bigger or whatever, if it could have been a dog bite. But doctors don't need to know specifically which dog bit this person's arm to treat them for a dog bite injury. Which again, that's what she's here to testify to, is that this was a dog bite injury, not to say that it was Chloe. I know the defense might want to argue it's Chloe. Dr. Peter, we're not actually ethically allowed to call ourselves Dr. Tragos. I joke around like with my wife. I'm like, listen, there's one when she's like, do you think this could be cancer? You know, she's always doing stuff like that, or WebMD. And I'm like, everything's fine. You're fine. The kids are fine. But I joke about, I'm the only doctor here, as a joke. But it's unethical for lawyers to do that and call themselves doctors, or to even insinuate where somebody might think that you're a doctor. I did have a lawyer in a deposition literally arguing with my client as to whether or not she's injured or her treatment. And he said, well, I'm a doctor. And I was like, yo. I didn't say yo. I was like, objection. That's absolutely inappropriate. You are not allowed to call yourself a doctor. And then he kind of moved on, but like horrible. Anyways, Bob, Dr. Peter, who do you think we see more of for the defense come trial? The new guy or AJ? Love AJ, but kind of like the new guy. I don't know how they're going to split it up. I think we're going to still see a lot of AJ. I think they are going to, I think that they are going to split up portions of the trial. And I definitely think this guy also mentioned that his law firm was on one of the cases they were citing, I think, with dog bite injuries. So this guy might be very specific to the dog bite and probably some other things, but I thought that was very interesting. I don't know the answer to this, but I think they're all going to hit specific parts, kind of how Yannetti and Jackson did the divide and conquer thing. And I think that's good. You focus on your portion of the trial and you hit a home run if you can.
Do you, Dr. Russell, need to go to the particular dog to determine whether a wound is from a dog?
No.
Have you ever heard of an emergency medicine physician needing to go visit a dog to evaluate and treat a wound from a dog?
No.
Is that a rational proposition?
I don't believe so.
Then he gets to kind of Brennan's argument about your opinions have changed. And I like his verbiage. He says, I can't remember if it was him or the doctor that says, my opinions have strengthened, and they explain why. And you're getting to see what trial is, because again, I really don't think this has to do with striking her as an expert. But if he's going to say, you changed your expertise, you changed your opinions, and that's so horrible, well, the defense gets a chance on redirect to come and say, why? Did things expand or strengthen? Yes, people talking about pig DNA. I think she did say at some point dog toys have pig DNA. I don't know if she's going to be qualified to be an expert to say things like that. We'll see. But let's hear her talk about why her opinions have changed / strengthened since trial.
You know, what's the word I want? Medical certainty. Very sure. High degree of medical certainty. Question. Reasonable degree of medical certainty? Answer. Yes, definitely. Question. And okay. And another question.
No, that's
it. That's it.
That's it. Yep. Now, to be fair and accurate, has your opinion that the wounds to the right arm of the decedent were caused by a large dog attack strengthened from June of 2024 until now?
They have.
Why?
Well, because between then and now, my opinions have been challenged. And as you know, any good doctor would do, they go back and reevaluate what they base their opinions on. And I did that. I reevaluated. I looked at the pictures again, the evidence again. I looked at peer review studies, and I was convinced that I was correct.
And had you looked at, well, what caused you to go look at the peer reviewed studies? What were you doing?
Yes. Well, so I looked at the peer review studies, and I periodically would do that throughout my whole career in terms of dog bites. But I looked at the peer review studies again because I was asked, why I didn't write a report, and so I was asked to write a report.
Were you asked to write a report before in June of 2024?
No.
But you were asked to write a report after June of 2024.
Correct.
Now let's go to is this what doctors and scientists do? Go back and analyze a matter, especially when maybe there's a challenge, another doctor is a question, there's a peer review process, whatever it is.
So basically, you're being challenged. You go back, you double check, and you're like, no, I'm right. In fact, I'm even more right than I thought. I think that's a pretty good argument. I think that's a pretty good response. She also mentioned how the doctor that wrote the deputy medical examiner didn't recognize the features or the patterns, and that she disagrees with them. And that's fine. That's what experts do in every single case. They disagree with each other. Then Hank Brennan gets back up on Recross, and he starts making some arguments with her about the other doctor's opinion. And she discusses how it wasn't the fatal injury, but it was one of the injuries. And then, so I don't hate his disposition as much as you guys do. I think at certain points, it's effective. I do. But if you're sarcastic and it turns out you're just kind of dead wrong, or a juror thinks you're dead wrong, that's when it really goes bad.
Effects that I would expect with glass or plastic.
You're telling us that a sharp piece of glass cannot cause a hole to a sweater.
No, I didn't say that. I said they would not, especially on multiple sites, the same exact type wound, defect.
If the glass was shattered and the glass had a number of pointy edges, wouldn't you agree with me that can cause a number of punctures in somebody's arm if the glass went into the arm and then came out?
Yes, but they wouldn't look like that.
You don't have any any past case of history to suggest what the glass shards would look like randomly when they hit somebody, do you?
That's incorrect. I have seen hundreds of motor vehicle accident victims who have been cut by glass. They don't look like that.
So from your perspective, the glass just remained dormant in the sweater, but never protruded through the sweater and caused the abrasions. That's your opinion?
I didn't say
Your
that.
Honor, could we have a sidebar on this? Sure.
I have no further questions.
So the objection was this was plastic, not glass, number one. Number two, talk about an own goal. To get her to say, with her expertise and experience, that I've seen hundreds of accident victims who have been hit by cars, this is not what that looks like. That's an own goal. That, I mean, and I think he was like, and tried to, come back with a, some kind of a sarcastic question or whatever. Like it laid dormant. So the glass just laid dormant. It's like, she didn't say it laid dormant, bro. She said that's not what it looks like. And frankly, she's definitely an expert on ER car accident injuries coming into the ER and what that looks like from my perspective. Wager said, should use the word physician to mean medical doctor of any kind, gets rid of murky, I'm a doctor by pharmacist, physical therapist, JD, etc. So Wager, lawyers are supposed to be ethical. They're supposed to be above and beyond. We take a professional responsibility class. We have to pass an ethics exam. We can lose our license if we do things that are unethical. So really, lawyers should never leave any doubt. They shouldn't ask questions that can be misconstrued. That's why in depositions and trial, if you don't understand a question I'm asking, ask me to clarify, and I'd be happy to clarify. That's how it's supposed to be. There's not supposed to be tricks. Really not supposed to be tricks. Please, no more Brennan. Well, we're done with his questions, but there's going to be some arguments we're going to listen to from him. So they get to some arguments. The state goes first, argues that she treats injuries. She doesn't identify them. Cites a case that says just experience isn't enough. She just gives an opinion without support. He really does not want her to testify. We're going to listen to just kind of a little clip of his argument here.
Why you should not allow this. This witness is in no position, kind of like the DNA and kind of like the opinion on dog bites, she is in no position to engage in differential diagnosis regarding the car accidents. She may have been a police officer. She treats injuries at the hospital. She's not an accident reconstruction specialist. She has never gone to an accident and done reconstruction. In fact, she never even went to the scene in this case. She never saw Mr. O'Keefe.
Bad argument. That doesn't make a difference in this hearing.
She doesn't even know about much of the evidence that exists. She didn't consider the black box. She didn't consider the speed. She doesn't know the angle of the collision. She doesn't know what Mr. Keefe was doing in his last moments. She has no idea about any of that, none. Yet she'll be presented on the stand as if she can exclude a car collision as the cause of those injuries. Not that they could be inconsistent with what didn't happen. How dare she get on the stand with no experience, no training?
No experience? How dare she get on the stand with no experience? He just got done saying experience is not enough because clearly she has experience, but he says stuff like, how dare she get on the stand with no experience? It's like, I mean, dude, you can make your arguments, but to be like offended that she has no experience, it feels like she's got some experience.
No methodology, no facts, and ignore reality and say this couldn't have been a car collision. It's funny that as a emergency room physician, she considers the basis of mechanics of injury based on what people tell her. They come in and say, I got bit by a dog, or a parent says, my child was bit by a dog. They rely on statements of witnesses. She didn't rely on statements of witnesses here. I hit him. Oh my God, I hit him. Maybe I clipped him. Maybe I hit him in the knee. Maybe he dropped his phone, whatever the statements were. All the various statements. An expert like her, she proposes to be, would consider the witness statements to try to determine the cause of mechanical injury. So for her to take the stand respectfully and suggest for a moment that this was not caused by the collision to Mr. O'Keefe, not only with no factual basis, in defiance of actual fact, it's repugnant.
Defiance of actual fact, like according to who? That's the problem. The things he's saying are facts. The defense is going to argue against, that's what happens in a trial. I did not find the argument overly effective for what he's trying to get done here today. I think he's going to have some good arguments that poke holes in her testimony, and the jury may not find her to be as credible as some other people do. Maybe some jurors will find her to be incredibly credible, but we'll have to wait and see with the trial. The defense gets up, and from my perspective, a much better argument for what they're trying to accomplish, the task at hand today. And he kind of right off the jump makes an argument I personally liked.
The greatest danger to the issues in this case, the greatest danger to a defense right to a jury trial and present its witnesses to have an entire motion supported by nothing but the assertions of an attorney on the other side. That is the greatest danger to our system. That is the greatest danger to a defendant being able to present their case in their view.
I don't know if I would say it's the greatest danger, but he's right. All that is a lawyer getting up and saying she's wrong, she's wrong, she's wrong. Look at the facts. Look at what else we have. What they don't have is a doctor saying she's wrong. The methodology used is incorrect. There is no, so there's no way to ever testify whether or not something's a dog bite. That's just not a good argument.
Remarkably, all of the arguments you just heard now do not come from a medical doctor, which Your Honor has said causation of an injury to a person in Massachusetts must come from a medical doctor. Where is...
So that's going to make the Kinsley thing kind of not good impeachment, right? For what they're trying to accomplish here today.
The affidavit. Where is the report of a prosecution witness to support one statement Mr. Brennan just made in 30 minutes? Where is it? It doesn't exist. I would like to start my argument and tell you exactly where I'm going to go. I'm going to...
I think that's a home run argument right off the jump. Now, just in effort to be even-handed and fair, I totally disagreed with his argument that the prosecution waived their entire argument by not objecting to his question. Do you, is your opinion to a reasonable degree of medical certainty? It's pretty clear they've objected to it at this point. And I saw some of the comments. Hit the like button. If I haven't said it already, make sure you guys hit the like button. So anybody that wants to come in, have the conversation. Listen, I get it. The comments, I'm sure some of them are going to be nasty. I like reading through, seeing how people see this, how they see the two lawyers, who I think did a pretty good job, right? Overall, I know you guys don't feel that way, but I like reading those comments. So hit that like button. It'll push it out there to everybody that wants to hear and see this hearing, at least my take on it and my recap on it. We are almost done here. Just a couple more things I want to say about it. He keeps mentioning that he believes that the judge, as the gatekeeper, should open this gate even more wide open than before. That she's qualified as a doctor to talk about medical causation, that it's a dog bite, that it was not a motor vehicle accident, and in the area of forensic pathology, which could be very dangerous for the state. And I frankly think that she should be able to. Now, will the judge expand what she allowed this person to testify? I don't know. But if she doesn't allow Dr. Russell to testify, I will be shocked. And I think that would be a miscarriage of justice. That would be a mistake. That would be an appellate issue. And just in case the judge forgot, this attorney very early on in his argument is like, hey, a judge one time gave his opinion on whether or not Dr. Russell should be able to testify at this. And she had much less information than you have today, Judge Cannoni.
Stronger in December than she was in June. So let me start out with the baseline for this hearing. The January 20th transcript, page 1-4. And if Your Honor will indulge me, it's what Your Honor said, and I'm going to read it verbatim. This was when Dr. Russell was challenged by the prosecution the first time. Line 15. I find that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked at that capacity, but that she does have specialized knowledge in that field that may assist the jury in that regard. So if you compare...
By the way, that judge, in case it wasn't clear, that gave that opinion and allowed Dr. Russell to testify about this dog bite was, in fact, Judge Cannoni in the first trial.
The level of information that Your Honor had at that time to reach the conclusion to what we have presented in this hearing, 11-page single-spaced report. And Your Honor noted before that there wasn't a report, so we wanted to respect that and get a report. Your Honor has sat through testimony, which I'm going to adduce, but not too much because you sat and heard it, and went through her qualifications, and we adduced much more of her qualifications, much more than were adduced when Your Honor first found that finding and made that finding. So let's start with the law. Mr. Brennan,
Pretty good argument. People are asking why she should even testify to causation. So medical doctors testify to causation in tons of cases. Like every single one of my cases, a medical doctor, usually the surgeon who did the surgery, or an ER doctor who somebody presents after a car accident with a broken leg, and they talk about here's what caused it, or usually it's spine injuries because the defense will argue it's old and, insurance company doesn't want to pay. And we're like, no, it's new. And how do you know it's new? What caused it? Well, because it looks like this. We use a radiologist to talk about the MRIs or the CAT scans. We use a surgeon usually to talk about, hey, well, when I went in there and did the surgery and removed the disc or shaved back the disc or did a disc replacement or put in the fusion, whatever, I could see that it did X, Y, and Z, which makes it look, which is indicative that it was acute based on X, Y, and Z, whatever. So it's usually medical doctors that are giving those opinions as to the causation and the severity sometimes of the injuries. At the end of this hearing, we did hear that Brennan is trying to exclude the accident reconstructionists, aka the ARCA crash daddies or experts. And I want to know why. He said it was a Rule 14 violation. So it didn't sound like it was going to be the same argument that they're not qualified, but instead that maybe there was a discovery issue or a notice issue. I don't really know. I'll have to read that motion when it comes out. If you guys want me to, let me know in the comments if you want me to break that down. But from my perspective, the state's just trying to strike every single witness. And maybe if they get one or two striking it from the defense, you take some of the bullets out of their chamber. And from my perspective, it's what lawyers do. And I don't think that there's something wrong with him for doing this. I do not see how he's going to be successful. I really do not see how she would ever allow that. Now, if Dr. Russell gets struck, the ARCA guys get struck, and Karen Reed goes and loses, sure, she's got a good appellate argument, but now she's convicted of this. Now it's a lot harder. So we'll have to wait and see. But this was incredibly interesting to me and shows us that this trial is going to be significantly more of a battle between these lawyers, significantly more fireworks, significantly more fiery between these lawyers, maybe even nasty, some would say, between these lawyers than the first trial. Judge Cannoni has her work cut out for her to keep them all at bay and keep things, from getting derailed. Let me know what you guys thought of it. Let me know if you agree or disagree with anything I've said. Like I said before, please hit that like button. Make sure you're subscribed as well, because we will be covering the second trial. And this is what we do. We try to keep it around an hour usually as a recap. We're not going to go through the entirety of every single day of trial. But I appreciate you guys being here. I appreciate you joining me. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.